Hi, everyone, and I would like to welcome you to our first in the a four-part series of a year in review for 2021, brought to you by Fasken's National Labour and Employment and Human Rights Group. For your reference, we're going to be hosting 3 additional seminars in this series. So we've got one on the 9th, the 16th, and the 23rd of November, covering labor relations, employment law, and human rights updates. So for more information on those, please visit our website and look for the Fasken Institute tab. We also keep all of our webinars updated on that tab, so stay tuned. My name is Jackie VanDerMeulen. I'm a partner in the Fasken Labour and Employment Group here in Toronto, and today I'm delighted to be joined by our guest speaker, Derrick Hynes. So Derrick is probably familiar to many of you. He is very prominent in the federal sector. He is the president and CEO of FETCO. For those of you who don't know, FETCO it's really an exceptional organization that ensures the federal employer perspective is represented in key policy decisions and discussions. Derrick is very tuned in to everything that's going on in Ottawa, and he's going to help share some of that insight with us today. So thank you, Derrick, for joining us. I'm also very pleased to be joined by 2 of my colleagues. Chris Pigott is a partner here in the Toronto group as well, in the Labour and Employment Group. And Stéphane Fillion is the co-leader of our national practice group, and he is based in our Montreal office. Chris, Stéphane, and I all have the pleasure of working with many of those of you who are joining on our call today, and lots of other employers in the federal sector. So thanks again. Before we get started, though, and we have a lot to cover today, because as you won't be surprised, there have been a lot of things happening over the past year and lots on the horizon, particularly with an election that's just happened. But before we get into all of that substantive insight, I'd like to just deal with a few housekeeping items. So we do have an online survey. We very much welcome your feedback on this presentation, on other topics that are of interest to you and your organization. So please, if you have a moment, click on the survey button underneath the video window and give us your feedback. Today's materials can also be accessed. There's a materials button under the video window as well, and we're going to be recording today's seminar. So that recording of materials will be emailed out to you after the event, so you can share it with others in your organization who couldn't join us today. Questions. We are going to try very hard to answer as many questions as we can, and we really do appreciate the questions that come in. So if you can please include those in the chat box, then we're going to address them at the end, and we will leave some time for that. I'm also very pleased to announce that we now have a closed captioning feature. So for those of you who would benefit from having closed captioning turned on, you can use the CC button at the bottom of the video window. Finally, if there are any tech support issues that arise during the course of the presentation, again, there's a tech support button, and one of our techs will be sure to reach out to you and help you out. The last point I wanted to raise is that we have lots of materials and resources at Fasken that we hope are very helpful to you in your workplaces and helping you through all these challenges, whether they're COVID related or otherwise. So there is a tab on our website that has specific information on sort of the key challenges that we see arising out of the pandemic. But we also have a mailing list that is specific to the federal sector. So you may be on some of our other mailing lists already, but if you'd like materials that are geared particularly to federally regulated employers, then please email any of us afterwards, and we'd be pleased to put you on that mailing list. So with that, I will turn it over to maybe Chris Pigott, who's Chris, in our Toronto office to get us started. As I mentioned, we do have a really packed agenda. We tried to limit this to just the kind of key issues from the past year and the key things that we see on the horizon, but there is lots going on in the federal sector, so we couldn't cover it all. But Chris, I'll turn it over to you to get started with what we see coming out of the election.
Thank you, Jackie, and welcome everyone. And indeed, I think so many of us in the labor, employment, and human rights world have been so busy the last few months with a number of things we're going to talk about today that it's easy to forget that indeed there was a federal election just a few short weeks ago. And indeed, we do have a quote unquote new government. just into power, reshaped Liberal government under Prime Minister Trudeau. That new government has proposed to do a number of fairly significant things in the labor and employment realm in the federal sector. And I'd like to spend just a minute running you through some of the highlights. Now, of course, the new government has been elected. Parliament has not come back yet. It is not sitting. Parliament is set to resume on November 22nd, 2021. So at this stage, many, if not all, of the Liberal government's policy proposals from the recent election are little more than somewhat abstract and vague promises. We will begin to see some meat put on the bones of these promises when Parliament returns in a few weeks. But what we do have are the details that were set out in the Liberal Party's platform during the election campaign. And indeed, the platform document, as supplemented by various speeches and announcements throughout the election, did provide a pretty good sense of what we can expect when Parliament does return in coming months. Now, important to note that the Liberal government is a minority government, but we should still expect to see some meaningful change in labor and employment law here. And that, of course, is well, really for two reasons. First of all, the balance of power in Parliament is going to be held by the NDP and or the Bloc Québécois. And as everyone here knows, for the most part, those parties are left-leaning parties that do tend to support almost invariably worker-friendly reforms. Second, what we are seeing right now in terms of political dynamics is quite interesting. We've seen, I think, a real leftward shift across all parties, a real shift to the left, at least in respect of labor and employment matters. And indeed, for all of you who are either living in Ontario or watching what's happening in Ontario right now, you will have seen what many of us thought or think to be a shocking development with the Conservative Doug Ford government announcing policies that it either rejected or overturned just a few short years ago, or introducing entirely new policies that many of us would be surprised to see come out of a Liberal government. So change is in the air, and let's turn to some of those changes right now. Next slide, please. So first of all, in advance of the election, the Liberals promised to introduce that within 100 days of the election, so within the next few months, they will introduce amendments to Part 3 of the Canada Labour Code that would provide 10 paid sick days for all federally regulated workers. Now, as many of you know and will recall, just a few years ago, the Liberals made changes to the personal leave provisions in Part 3 of the code that provided for 3 paid personal days for illness and injury, among other things, such as carrying out responsibilities related to the health of a family member. So it's not clear yet whether the Liberals intend simply to add 7 additional paid personal days to this existing section in Part 3 of the code, or create new paid days off that are specific to sick leave and that are a bit narrower than the current personal days. But we will know quite soon, as again, the Liberals have promised to introduce this legislation within 100 days of the election. So next couple months. Derrick, did you have anything you wanted to add about this commitment?
Yeah, I mean, we've been following this one closely as well, Chris. I mean, as you can imagine, this is has substantial cost implications for employers if, in fact, it is the employer that is expected to pay for these paid sick leave days, which is yet to be defined. So like anything, the devil is always in the details. We are anticipating and hoping that the new minister will engage in a meaningful consultation with stakeholders around what this thing actually looks like, how it interacts with the personal leave days, as you've just noted, how it interacts with current leave provisions that exist within organizations, whether organizations have paid sick leave currently or short-term disability plans. We think there are a whole bunch of questions here that really need to be answered before this policy framework is rolled out. It will have a different impact on an organization depending on whether or not they actually have some sort of provisions in place currently. But we do hope that the minister engages in a meaningful consultation so we can talk through these sorts of things and avoid a policy with unintended consequences.
Thanks, Derrick. And I think on the legal side here, what a lot of us in private practice, and indeed I think the in-house legal community are expecting, is to see maybe not a flood, but certainly some grievances, some litigation, essentially taking the position that these 7 new days exist over and above any existing paid sick leave entitlement under a collective agreement or otherwise. So that's going to be an important issue for consultations with the government, and certainly an important issue for all of us to watch. Next slide, please. Turning to an entirely different commitment, and this relates to Part 1 of the Canada Labour Code, the Labour Relations section of the code. The Liberals also committed in their platform to create a quote unquote fairer collective bargaining process by prohibiting the use of replacement workers by an employer who has locked out employees. So this would not, at least as it's been described in the Liberals' election documents, this ban on replacement workers would not apply in the context of a strike initiated by a union. It would be limited instead to situations where the employer has locked out employees during a labor dispute. Now, what's interesting about this is that we've seen proposed replacement worker legislation in the past, and typically it's been expansive, very broad bans on the use of any workers, whether contract staff, sometimes management from within the employer, to fill in for striking or locked out bargaining unit members. It is not yet clear whether the Liberals are contemplating something so expansive, although significantly, I think, the Liberals, some members of the Liberal caucus did support a very broad ban on replacement workers 10 years or so ago when legislation was then in play in the House of Commons. Ultimately, that legislation, which was a block private members bill, did not get anywhere after the Liberals, in their wisdom, I think, decided that it was probably not a good idea to fundamentally change the way in which strikes operate and lockouts operate. But it is possible that there will be Liberal support for a broader prohibition than many of us would like to see on the use of replacement workers. And this is particularly the case, of course, because both the Bloc and the NDP have tended to support, and certainly the NDP does right now, a total prohibition on the use of replacement workers during a labor dispute. So it will be very interesting and I think important for all of us to watch negotiations between the parties as they sort through the mechanics of these amendments. Derrick?
Yeah, I couldn't agree more. It will be an issue to watch closely for all the points you just raised. This issue is, in many respects, the Groundhog Day issue of federal labor relations. This issue of anti-replacement worker legislation has come up probably 12 or 15 times in the past 20 years. It consistently gets voted down. What I think has changed is the Liberals generally have en masse voted against this because they have agreed with our perspective, which is that the current system has balance. And I won't get into all the details of that to take too much time, but we generally feel as though the collective bargaining situation that exists in the federal private sector right now is balanced. So there is no need for anti-replacement worker legislation. It's interesting to see this that it may be confined to situations of lockout. But again, as you point out, that may not be where we land ultimately, given the push that will undoubtedly come from some parties, such as the NDP or the Bloc. So it's certainly a concern to employers. It's not an issue where we think there's a problem that needs to be solved. So it's a bit of a surprise and a disappointment to see it here and to see the Liberals now more largely supporting it than they've done in the past. So it's an issue certainly to be followed closely.
Thanks, Derrick. Next slide, please. And last but certainly not least, on an entirely different note, the Liberals also committed in their platform to reintroduce legislation that had been tabled really just before election season began in June of this year. And this is legislation known as Bill C32, which was legislation to amend the Official Languages Act and make other changes related to the substantive equality of the French language. This legislation is complicated, and we don't have time during this session to get into a detailed discussion of it, unfortunately. But in essence, what Bill C32 tried to do was make changes in both the federal public and private sectors that worked to recognize the right, while at work and in the customer service realm, to be served in French if you were working or being served by a business in Quebec or outside of Quebec in a region with a strong Francophone presence. And let us drill down a bit on what that means. Next slide, please. So what are some of the key features of Bill C32 that we expect to see in the retabled legislation that the Liberals have promised to reintroduce within 100 days? Well, there are many important features, but here are the central ones. First of all, the legislation would require private federal sector businesses to protect and promote French as a language of work and customer service. Now, what does that mean in the areas of workplaces? Well, it means a couple of things based on our read of the legislation. First of all, it would give employees who are working for federally regulated private businesses a right to carry out their work and be supervised in French. It would give them the right to receive all communications and documents from their employer, including things like offers of employment, promotion documents, collective agreements, really all important employment-related documents, to have those documents in French. And it would give those employees the right to use work instruments, computers, computer systems in French if they so chose. Now, again, this is not all federally regulated private businesses. It is federally regulated private businesses in Quebec or other regions with a substantial Francophone presence. The legislation would also give the Commissioner for Official Languages a very wide range of robust new powers, including a variety of compliance-oriented powers, such as the ability to enter into compliance agreements with private businesses, the ability to issue orders to private businesses concerning the use of the French language, and the right to make public recommendations, findings, and summaries of investigations. And of course, I've just hit on a very important piece in that last power. The commissioner would have quite a wide-ranging power to conduct investigations in respect of the use of French in workplaces. Related to that, the commissioner would be given the authority to receive complaints from employees of federally regulated private businesses concerning the use of French in their workplaces. The complaints process is very extensive and detailed. One thing to note is that ultimately, if a complaint could not be resolved at the commission level, then the commissioner would have the ability to refer that complaint for adjudication and a decision to the Federal Labor Board, the Canada Industrial Relations Board. And so this is a whole new complaints process concerning a workplace-related right the right to use French in the workplace being created out of the Bill C32. Now, importantly, while the legislation was very detailed in its first inception, there were a number of critical elements that were to be defined by regulation, including, perhaps most notably, the fact that the legislation would only apply to businesses who had a certain threshold level, a threshold number of employees, and the number of employees required to trigger the application of the Act would be defined in regulation. Those regulations obviously were never created, and I'm sure will be the subject of extensive and heated consultations after this legislation is retabled. A number of other important terms and items in the legislation were also to be defined by regulation, including, for example, what it means to be a region with a strong francophone presence. The legislation doesn't define where those regions are, what they look like, what their key features are. Those will all be defined in regulation. And so, to summarize, and I'm unfortunately don't have time to go into any more detail on this important new piece of legislation. There's going to be a lot in that legislation, but a lot still to be worked out in the consultation and regulation making process that will probably begin later this year or early next. So stay tuned for news on this front. Next slide, please. There's a lot more that we could talk about here, but we're not going to because we simply don't have time. I simply wanted to flag a few other changes that we will likely see, at least in proposal form, in coming months during this government. First of all, the Liberals have committed to create a right to disconnect, meaning what is essentially a right for employees to, after their shift, their hours of work, to be able to go home, turn off their email, and not worry about being contacted by their employer. Ontario, interestingly enough, has just introduced a requirement to have a policy in workplaces around right to disconnect. That was a bit of a surprise out of the Ford government. Not so surprising to see this as a Liberal platform proposal, given that something along the lines of a right to disconnect has been considered in consultation and for a number of years. But it does seem like the Liberals will be pursuing this in coming months in legislative form. The Liberals also made a commitment to strengthen rights for digital platform workers under Part 3 of the code. It's not at all clear to me what they're intending to do here. I'm going to be interested, Derrick, if you have any thoughts on this, and I'll let you chime in a minute. What jumps out at me is the fact that most of the commonly thought of digital platform workers, your delivery drivers, they're subject to provincial regulation. So I'm not entirely clear on what types of workers the Liberals believe will be captured in this bucket. Are they talking more generally about independent contractors working in the quote unquote broader technology space? I'm not sure, but this will be something to watch. And last but not least, it's important for us not to forget that there are a number of other changes that were made over the course of the past few years that have already been enacted via legislation, but have not yet come into force, or are the subject of, or are to be the subject of future regulations. These include things like the $15 minimum wage that will come into effect at the end of December of this year across the federal sector. Changes to Part 3 of the code, which provide enhanced notice of termination entitlements to federally regulated employees, and equal pay for equal work provisions that will prevent differentiation between workers based on their employment status, meaning whether they're full-time, part-time, or casual workers. These and a number of other changes are coming into force in the next year or two. And it will be important, I think, for all of us to keep our eye on those changes as they get closer. Derrick, did you have any final thoughts on these other possible changes I've just talked about?
Yeah, on your first two bullets, Chris, the right to disconnect and the strengthening rights for digital platform workers, these are both carryovers from the last election campaign and have been in the Liberals' list of campaign commitments for some time. But they're at different stages of their development. The right to disconnect has actually, over the past 18 months, gone through quite a substantial consultation. The government has hosted 12 consultation meetings in a tripartite way on this issue. I've been at all of them. And essentially, advice has gone to the minister on how to proceed. That advice is not unanimous. So the government has committed to, as you can see on your slide, co-develop an approach to the right to disconnect. But it's pretty clear that those of us on the employer side and our friends on the union side have vastly different perspectives on how this should be approached. The union side definitely wants a prescriptive legislative framework for the right to disconnect, whereas on the employer side, we have conceded that it is something that should be looked at, but should really be approached more from a policy perspective and left to employers and their union counterparts to sort out within their own operating environments. So quite a chasm between those two perspectives. So it will be interesting to see where the new minister might take this conversation. The gig work is really new. We've had some preliminary discussions about it. As an employer organization, we keep asking the same question that you've raised, Chris, and that is, who are these workers? When we look at the framework of the federal private sector, we don't know exactly who these digital platform workers are. So before we can solve that problem, it would be really helpful to better understand what problem it is that we're trying to solve. Obviously, gig work is a big thing, but we're not so sure it's a big thing in the federal private sector and may not need a discrete solution accordingly.
Thanks, Derrick. And with that, I will turn it back over to Jackie.
Thanks very much. And just on that right to disconnect point, I think we're already seeing it pop up, certainly in bargaining mandates. Obviously, the pandemic has sort of shifted the work environment for many of us, as you can see from our panelists today. And so with that discussion and having employees work remotely as well, a lot of those kind of topics are making their way onto the bargaining platforms of the union. But with that, I'll turn over to the task force that's been announced. So this is another item. Obviously, large federal sector employers are well aware that they've got obligations under the Employment Equity Act. At a very high level, those obligations are to sort of gather and analyze your demographic, your workplace demographic information, with a particular focus on the equity-seeking groups that are represented on screen. So women, and I say Aboriginal people in quotes because that's the term used in the current legislation, persons with disabilities and members of visible minorities. And ultimately, you're required to use that information to try and develop policies and practices to promote more inclusive practices in the workplaces and remove some of the barriers to equal opportunities for members of those groups. Next slide, please. But I think that Employment Equity Act came into force, I believe it was 1996, and society has evolved quite dramatically since 1996 with our understanding of equity rights and diversity inclusion in the workplace. The dialogue has really shifted, the terminology has shifted, and the factors have shifted. So we've got an aging demographic. It's more important to now consider and incorporate various different types of disabilities and factor those into the workplaces. Shifting immigration demographics as well have prompted increased representation of individuals with visible minority groups within the workplace. Everything has shifted. And I think what this task force is really doing is saying, look, we've got to look at the act again. 25 years onwards, let's reconsider these definitions. Let's reconsider the framework and the groups that we're really focused on and how we actually better achieve diversity inclusion in the workplace. Yeah, sorry, next slide, please. So the task force is really the task force is charged with doing a fairly comprehensive review of the legislation. and analyzing it from the perspective of what can we do better? How do we change definitions? So for example, definitions to better reflect Indigenous populations in Canada, not using outdated terminology and having more inclusive terminology. Are there different ways that we can try and achieve the goals that are sort of being sought after here? Are there different compliance mechanisms that are going to be put into place? Basically, everything is on the table from that perspective. So the task force is going to meet and to put its head around all of these issues. It's going to have representatives from a variety of different sort of areas of society. And I'm sure Derrick has got a lot more insight on that I'd love to hear from you. But we don't anticipate its results anytime soon, but it is something just for organizations to keep an eye out on, that we expect fairly substantive changes to this sort of legislative regime as a whole over the next few sessions of Parliament. So. Derrick, do you have anything you want to add to that?
Yeah, I mean, you're right. This act is well past its expiration date, and it is well overdue for a modernization. We've actually been asking the government to do this for about 6 or 7 years. So we fully support this initiative. And for all the reasons you've just stated, the whole conversation has changed in this space where we need to move beyond quote unquote employment equity and checking boxes and engage in a comprehensive and mature conversation about diversity and inclusion, which many organizations and their unions are already doing. So this is a very positive development. The only, I think, sort of guiding principle we've been putting forward to the government is, let's root this in the practical realities of the workplace. Let's not make this an academic exercise where we end up with lofty goals that are not attainable. Let's really make sure that this is rooted in the realities of the workplace, and it really is layered on an important conversation about diversity and inclusion that takes us into the future and builds on what the previous act accomplished.
No, I think that's really important. And Bill, I hope it will build too on a lot of the work that our clients and others on the call have done. I mean, the banks have been real sort of leaders in this space and have worked very hard on their own initiatives. So my hope, at least when I see the results of the task force, is that it's not requiring those who have already done so much work in this space to kind of reinvent the wheel and start from scratch on these fronts, but instead we'll build on a lot of the initiatives and thinking that's already gone into this. So. But with that, I will turn it over to the topic of the day, which is mandatory vaccinations, and over to Stéphane.
Thank you, Jackie. So I'm in charge of the thrilling subject of mandatory vaccination. Maybe just as a quick introduction, this is still, aside from jokes aside, it's something that's important, not only in the federal sector, obviously those who are specifically, who have this requirement imposed upon them, but it's also important from a Canadian perspective, because it will also influence, I think, how courts will see mandatory vaccination in the future when we're seized of cases like this. I used to say before the federal came out that I always felt like weird when I was talking with a private employer who wanted to impose mandatory vaccination while the government, at least in Quebec, was not imposing it. I thought it'd make it look weird. How can I justify that I'm imposing it if even the government is not doing it? So I think it's a big step forward, not only for federal employer, but also for all employers across Canada. On the downside, I'm always kind of on the fence when it comes to mandatory vaccination like this being imposed through press release, a policy that's published on a website, a policy that you can get when you search a lot on the internet, and then looks like it's a lot of interpretation coming on from one press conference to another. But this is what we have to deal with. So everything that we're going to be talking about is based on everything that I could find. But obviously it's probably going to evolve in the future. And obviously, Derrick, if you have things to add as we go along, please chime in. I will start by, next slide. So I would start with, where we started, where we were before the election. I wanted to look at the election platform because there's one particular aspect that was of particular interest. So some of you might remember that the Liberal election platform include requiring travelers on interprovincial trains to be vaccinated, also impose vaccination across the federal public service, work with employers in Crown Corporation and federally regulated workplace to ensure vaccination is prioritized, This is going to be regarding the kind of the other sector piece. But finally, and last but not least, I should say, table legislation to ensure that every business and organization that decides to require a proof of vaccination from employees can do so without fear of a legal challenge. So some kind of immunity be granted to employer. I'm pretty sure a lot of federal employers were counting on this because obviously, you know, while everybody believes in mandatory vaccination, there's still a lot of risk involved, and we're going to be talking about that later on. But so far, we haven't seen any trace of this particular aspect. But I'm going to come back on this particular piece later on. In addition, it was made clear at the time, it was actually on September 8th, that people who were unvaccinated would not be able to work. Next slide. Most of this is actually, you know, been put into effect since. So you have the requirements that have been announced. So on October 29, 2021, so we're already in the past, all public servants in the core public administration, including Royal Mounted Police, had to confirm their vaccination status. And then they had kind of a transition period of 2 weeks until November 15, 2021, before they would be put on administrative leave without pay. One thing, and I'm trying to incorporate questions that were raised, you know, prior to our presentation. One of the people, you know, mentioned, you know, but how are we going to treat people who were on sick leave at the time on October 29, 2021, who were still on sick leave on November 15, maternity leave, paternity leave, parental leave, whatever leave. And actually, when you look at the policy, and we're going to go into a bit more detail, there doesn't seem to be any distinction. Like everybody has to disclose, and everybody would be put on leave without pay if they don't meet the requirement. But it's hard to believe that this was really the intention, especially since, you know, as we're going to see later on, there's a possibility for employees who decide later on to kind of see the light and get vaccinated to come back to work. So I'd have a hard time believing that this was meant for people on maternity leave, as an example, who are not coming back to work within the next 2 or 3 months. But I don't know if you've heard anything about this, Derrick, or maybe it's kind of too specific at this point.
Yeah, I'm not. It's a great question, but those are the things that, you know, get worked out. The devil in the details, right?
Yeah, exactly.
I mean, I couldn't agree more with your point about some of this has been introduced via press conference and press release. And as a result, you know, there's a bunch of holes and outstanding questions that come. And just as sort of an upfront editorial comment for me, it really did not help this whole process that this was announced and 2 days later an election was called, and then nobody could talk to any bureaucrats. Like, that was really problematic. When you go into an election mode and the caretaker convention kicks in, you can't really have a formal conversation with the government. And it's not a partisan comment, it's just a practical reality comment that, you know, something as significant as this 2 days later to go into an election campaign really made working out these details and answering the questions like you've raised just that much more difficult.
So jumping back, another element that is important, it applies to employees who are working remotely or teleworking. In the COVID-19 policy, there's a justification that is that all of the employees may have to present at work on an ad hoc basis. So as a result, that's why they justified imposing mandatory vaccination. Note that it also applies to employees who are working abroad, so also out of the country. If you're working for the government, it also applies. Obviously, the big thing from the private sector was more the announcement that it will also apply to air, rail, and marine transportation. We're going to switch to the next slide. Maybe I just be aware that I've put a lot of material in the slides. I'm not necessarily going to read through all of them. It's just that I wanted to make sure you had all of the information and you could look at it later on. So let's switch to the next one, actually. So mandatory vaccination applies. You have the list here. It's kind of a, because you mentioned something, Derrick, earlier on about, you know, whether it would apply to all employees or not all employees. And it's kind of weirdly drafted because when you look at it and you see airlines and airports and other organizations who have employees who enter restricted areas, it raised the question of whether it would apply to all employees of an airline, all employees of an airport, whether or not they enter restricted areas of airports, especially since, as we will see later on, the entity has to adopt a policy that will basically meet the standard of what's imposed by the government, and the government has imposed it to everyone, whether working remotely or not. So that's certainly another question that could be raised. So you have federally regulated railways, marine operators, and I was saying probably to apply to all employees. I don't know if you have something to add on this particular aspect, Derrick.
Only to say that my assumption is, to answer your question, it would apply to all of those employees in those particular sectors. Where there is some difference is for those other employers who are accessing those restricted sites. So those employees who have that restricted site access would also need to comply with these requirements.
That was my interpretation. The only reason why I'm being careful is probably a lot of you have had like conference calls and meetings perhaps with information from the government. So maybe, sometimes there's more information coming out than what's available publicly. Next slide, please. So the content of the policy in terms of the requirements, so each organization must adopt a rigorous policy that will include a provision for employees attestation declaration, include a description of the consequences, and meet the standards. For those of you who might not have seen it, it's available online. So maybe you can have more details in it. And after a short phase-in period, each organization is required to guarantee that employees are fully vaccinated, or they will be unable to work. Next slide. So in terms of enforcement, here's how it's been announced. Transport Canada will use its authority to apply it, and it's obviously in the sector that it controls. And there's pretty hefty penalties in case of non-compliance. It's weird that you'd have these severe penalties and at the same time kind of a lot of documentation that is pretty vague or ambiguous, at least to a certain extent, but I think it sends the message pretty clearly on how the government is aimed at applying it. Next slide. So you have the information about, a corporation and separate agencies that are required, but what about the other sector? Prior to the election, a lot of employers in the private sector that were not in the transportation sector already announced publicly that they were adopting mandatory vaccination policies. So I'm pretty sure a lot of them were hoping for the legislation that would protect them, but that's not the case at the present time. And while, I looked it up just a couple of hours ago, the House of Commons will reconvene on November 22nd. So obviously there's room for maybe more legislation coming on, but so far I haven't seen a word on any kind of platform or press conferences or things like that about this being a priority or this being adopted anytime soon. Let's hope it changes. Next slide. So you have more details here about, what's the policy. So more details on the policy that you can look at. I think it's a good thing, also not only for obviously those who are governed by it, but also people who would like to adopt maybe a mandatory vaccination policy in the future. I think there's a couple of good key points, and obviously for employers in the transportation sector, abiding by these rules is going to be mandatory. So you'll see the things that I was mentioning before. So disclosing vaccination status, 2 weeks deadline, and then there's an online training session on COVID-19 vaccination, probably to kind of convince people to go and get the vaccine. 2 weeks after, we cut access to the workplace, and the people are placed on administrative leave without pay. Next slide. And this is what I was talking about earlier on. So employees who are partially vaccinated, They are placed on leave without pay if they have not received their second dose 10 weeks after their first dose. There's also room for someone who had previously not been vaccinated and suddenly decides to become vaccinated. They will resume work and have their pay reinstated, and they'll again have this 10 weeks delay to get their second dose. But obviously, all of them could be subject to temporary measures for the period of time where they remain partially vaccinated. Next slide. So I mentioned earlier the absence of the protection. And when I was mentioning that there was no trace of this legislation, there was actually a press conference where Justin Trudeau mentioned that he felt like he had already delivered on his promise on vaccination without mentioning the table legislation. So that's why, I think there's reason to be nervous on whether it will happen or not. Personally, I would recommend that we get prepared in case of a litigation instead of waiting for the government to adopt it. So what's the potential legal action? I think in this particular area, obviously those who are subject to mandatory vaccination by the government are not necessarily in the same place as the other employers in the other sector. It doesn't mean that it's automatically valid. I'm kind of assuming that the government intention was that by adopting mandatory vaccination like that, they would probably have to take the lead on it. And if there were to be ever litigation, they will take it on instead of leaving it to all employers. I don't know how much this is going to happen because a lot of unions at the federal service have explained that they are in favor of the policy. So maybe it will not come. But I wanted to kind of list what are the potential elements that could be raised. Obviously, there's human rights, and this is something that's been raised a lot of time based on an allegation of discrimination and failure to accommodate, whether it's religious or medical. Right to privacy has also been invoked as a reason to refuse to get vaccinated or at least to disclose vaccination status. The right to make decisions about medical treatment is also something that's been raised in a couple of cases. And for all of those of you in a unionized environment, whether the policy is abusive, unreasonable, or discriminatory. And that's obviously without taking aside the recourses for constructive dismissal or unlawful dismissal that could arise if it leads to a dismissal, or if it leads to a long leave without pay. Maybe we can jump to the next slide on religious accommodation, because that's a subject that's been raised several times already. So Prime Minister Trudeau, when questioned on it on October 6th, said exemption from mandatory vaccination would be extremely limited, rare, and hard to obtain, and that a mere personal conviction would not be enough. Next slide. So how will the core public administration deal with requests for accommodation? Again, I think it's something that can also be used by a lot of employers, whether even you're a federal employer or not. So they've prepared a process, so informing the employee of its obligation, gathering the relevant information on the religious accommodation requested. That's the one thing I would like you to keep in mind, making a decision, implementing the decision, and documenting the process. It also states the employee's responsibility, informing their manager, again, based on a certified medical contradiction, religion, or another prohibited ground, and provide their manager with complete and accurate information necessary to identify appropriate accommodation. So a lot of reference to justification or documentation to support accommodation. Let's skip to the next slide, please. There's also another directive, the directive on the duty to accommodate. This is a document that I was not even aware of, but that's been adopted actually in April 2000. So it applies to all accommodation. And again, there's a process described where again, we're talking about requesting additional information from the individual. So that's also important. And you'll have the federal public service manager aspect. So at this point, I would like to kind of open a parenthesis. Just for you, a lot of people have been wondering about, how many of these requests for accommodation are we actually going to get? Based on experience, because this is something that could have been raised at any time, there aren't many. In fact, I was asked on a recent mandate to kind of do a quick research on what kind of religions could have a prohibition against the vaccination. And while it's in no way an exhaustive review, the Vanderbilt University in the United States, and you can Google it up, actually has prepared some kind of a research where they've looked into all major religions, and even they went as far as looking at some much minor ones, and actually pretty much all of the main religion have no prohibition against vaccination. Some of the names that you might not even remember who have prohibition are the Dutch Reformed congregations, the Faith Tabernacle, the Church of the Firstborn, the Faith Assembly, and the End Time Ministry. So all, pretty uncommon, I would say, religion that we don't see often in the marketplace. We've had a couple of attempts made recently. I've read a case where somebody actually from a Catholic raised that faith and some excerpts from the Bible to say that this religion supports freedom of conscience, and as a result, he's free to decide not to get vaccinated and protected by his religion. Obviously, there's no decision rendered on this, but that is certainly not going to be acceptable. So, in other words, the reason why I was mentioning this is, and I know a lot of employers are unwilling to start and have a discussion and argument with an employee about whether their faith requires it or not. But what I've seen so far is more the kind of process that is described in the directives, actually, and asking for more information, and not just saying, oh, the employee is talking about religion, I should probably grant an accommodation based on this. A lot of my clients who've had some talks like that have been raised like in the corridors or things like that, what they did is they said, please fill a form and explain to me what's your religion, why does your religion prevent you from, and give me more details on this. And in most cases, people will just let it go and forget about it, and you won't get into an argument. But I'm just saying, I think it's important to at least ask for more information instead of just accepting it. I also wanted to mention that, last point I wanted to mention is some clients are asking, could I ask for, in terms of documentation, a document from an authority of that religion, of the religion of the employee? So could I ask like a priest to write me a paper and explain, if this is really warranted? I thought at first that this is probably not a requirement based on what we will see in some of the case law. However, just to mention that the Custom and Immigration Union on their website has already kind of taken that position, because they're suggesting to their employee that they talk to their priest or any of their religion authority, and they get a paper supporting their claim that they should get an accommodation. So that might be interesting if it comes up later on. Next slide.
Stéphane?
Yes, go ahead.
Just going to jump in there. I'm hearing on the religious accommodation side, I'm hearing similar to what you just stated, and that is that many employers, particularly the large employers like those that will be within our membership, are asking for detailed documentation on the religious side. And in addition, some are, as you know, asking for some sort of documentation from the faith leader in question. And my sense is that is quieting a little the requests for religious accommodations. They're still coming, but I don't think they're coming in wide swaths for all the reasons that you just stated, that the bar is meant to be high. And once an employee is asked for that level of detailed documentation, it does not result in an increase in requests in this regard, for sure.
Stéphane, you're on mute.
So I guess I lost my bet. Just an inside joke. So in terms of Amselem, because you know what I was referring to when I was mentioning that you know, it wasn't clear if you had the right to require this. It's based more on kind of a you know, broad interpretation of, you know, the requirements that were stated in the case of Amselem. In that particular case, you know, there was a discussion about whether we can challenge the employee on whether it's really mandatory in his religion, or if it's subjectively or obligatory or even customary. And at the time, the Supreme Court said that not any mandatory or perceived as mandatory nature of its observance that's not the only thing that is protected, and that an inquiry into the mandatory nature of a knowledge religious practice is not only inappropriate but also plagued with difficulties. So, you know, if we get documents from you know, from an authority of that faith, you know, it really depends. It might not be something that is absolutely mandatory for everyone, but it doesn't mean that it cannot be required. I also wanted to just leave at the bottom the recent case of Singh versus Montreal Gateway, where, you know, just to remind you that the objection you know, must be more than trivial or insubstantial. So that's another thing to be careful with when looking into it. Next slide. And I'm going to go more quickly. So that's kind of just the process for discrimination. So let's jump to the last slide. And I'll actually end my presentation on this one. So I thought I'd dress up a list of what should be considered in establishing the validity and reasonableness of the mandatory vaccination policy. That's kind of the KVP aspect of the test, and the bona fide requirement if we ever get there. And we've had numerous requests, you know, on whether we could impose mandatory vaccination, especially after a lot of the US employers came out and adopted mandatory legislation, and we were often seen like those who were behind the crowd and not following it and always putting obstacles. But you know, we've kind of agreed with a list of elements, and again, it will vary from one sector to another, although all of this varying from one sector to another, varying from one position to another, is a pure HR nightmare in most instances, like starting to explain to an employee that he's subject to it, but not this one, and this one, yes. And this is kind of a nightmare, but that's still the test. So I've kind of dressed up a list of elements that you might want to prepare for in case of litigation. So the nature of the employee's work, obviously, whether it's an office job or it's a production job, whether employees are working very closely, remotely, and stuff like that. The employee's particular workplace, obviously, that's pretty obvious. Whether the employer is complying with statutory or regulatory mandate. I thought this was important in this particular case, both for everyone in the transport sector, but also to suppliers, for example, who might be forced to respect that policy. I think in this particular case, if I had to go to court and it's imposed by the government, I'm in a much better position, because I can say that obviously if the government has imposed it, it must be based on public health authorities. So that gives more power, I think, for an employer in the private sector. Whether the employee holds a position that involves public facing, I think it's pretty clear why we're talking about that, or if the employee interacts with vulnerable members of the population, that will certainly be something important. The one thing that I've been very, very worried about is whether current precautions have been sufficient to keep employees safe at work. When we're talking about whether the policy is reasonable, we often ask, was there another way to implement it without going for mandatory vaccination, which raises issues of, as I mentioned earlier, privacy, right to decide on medical treatment. And that's someplace, and you know, depending on, I've asked a lot of employers about their situation, whether they've had outbreaks, you know, when were the last cases, how many can they relate to their workplace? And the problem at this particular time is most of them cannot give me any cases. Even large employers sometimes will have had like 15 cases over the last 8 months, and they can't even demonstrate with a hint that this results from the workplace. So obviously, it makes it harder to determine that current precautions have been insufficient. But if that's been your case, it's certainly something that will be important. Whether there are less intrusive measures available, I've seen a lot of employers who, instead of adopting mandatory vaccination, have imposed different measures depending on whether you're vaccinated or not. So that's certainly something that could be interesting. The vaccination rate in the organization, I've seen things going all over the place. Like, I have clients who call me and say, my vaccination rate is at 94%. Can I impose mandatory vaccination? And I say, okay, but you're already at 94%. I mean, that's something, and it's going to be harder to demonstrate why it's necessary. But I also have employers who will say they're at 55 or 60%. So obviously that could change your perspective. And the last thing I wanted to kind of talk about is the overall COVID-19 situation. One of my concerns has been that, we've been living since the beginning of the pandemic with employees, in some cases, reporting to work every day, being in a position that involves public facing or stuff like that, with all of the measures that were put in place. And the situation is actually much, much better than what it was. And just to remind you of how it went, I just took like about the last 12 months. In December 21, 2020, we had over 5,500 cases that particular day in Canada. On April 7, I took specific dates, we were at over 9,500 cases. On October 6, when the announcement was made, we were over 3,000 cases across Canada. And on October 27, and you're not going to believe me when I'm going to say this number, but you can look it up on the internet, we were across Canada at 384 cases. So basically, we're extremely low compared to what it was. Obviously, some will say, well, we better use the rolling average, but I think the rolling average has been announced recently was a bit over 1,000 cases across Canada. So obviously, it's going to be something that will need to be discussed. At the same time, there's a management decision to be taken there. A lot of employers are saying, you know what, I'm going to go with mandatory vaccination. And if ever in 6 months, 8 months, 12 months from now, somebody says I was wrong, well, so be it. At least I've proved that I had some leadership. Others have told me, the problem is when you're bringing back people to work and you're telling them that some of their colleagues will not be vaccinated, you have to deal with the level of fear in these employees, and you don't want to lose them. So that's another concern. But at the same time, we have to be clear that I think we cannot say it's a safe decision, especially if it leads to dismissal or someone being put on leave without pay for a long period of time. Maybe just an end note, on November 15 in Quebec, the Superior Court will render a decision on the validity of the mandatory vaccination in the health sector. So that will certainly be interesting. It's obviously at a provisionary level, but still, it might be a good indication. So I don't know if, Derrick, you wanted to add something at this particular point. I think I've talked a lot.
Stéphane, that was an absolutely superb review on the lay of the land now. It's a ridiculously complex and multi-layered approach that we're seeing. There are tons of questions that are coming in. I think you actually answered a bunch of them in these slides, which is really helpful. I mean, for me, from where I sit, I mean, obviously, this is not an ideal situation in the midst of this pandemic. Nobody wants a mandatory vaccination policy. Employers aren't screaming from the hilltops to have this regulated and to do this. But this is the world in which we're living. It's unfortunate. The science is pretty clear that vaccination is what's going to get us out of this ridiculous mess that we're in. So, I mean, the questions that I have from my seat that I have been posing to the government, now that you can actually talk to the government again, is how they came to the conclusion on these three sectors, outside of the core public service. How did they come to air, marine, and rail? And why did they choose the legislative levers that they chose? Was it just because they exist and therefore they can be tapped into, so there's an efficiency to it? Or was there some broader plan at play that has not been explained? I've watched every press conference and read every press briefing, because there are a lot of sectors that are left out. Many major employers, following the Prime Minister's plea, back in August, stepped up and developed their own mandatory policies and have now rolled them out and are dealing with the consequences that they bring. And it's not going to be a surprise for you to hear that it's messy. I mean, it's complicated, right? To get into these situations of putting people on leave and having conversations about terminations as a result of this. But we have, this sort of scattershot approach to this now, where some employers have mandatory obligations from the government, some have strong encouragement from the government. Some are not quite there yet because they don't quite know where the regulatory or legislative burden is going to lie. The question I have asked numerous times and has not yet been answered is why we did not entertain a conversation about using the Canada Labor Code. I mean, Part 2 of the Canada Labor Code speaks to occupational health and safety and the employer's obligation to provide a safe workplace. How that lever was not pulled, I don't quite understand. So when you look at job types and you look at things like railway engineers, what differentiates a railway engineer from a courier driver or a telecom technician? When you think about the nature of the work and coming into contact with other human beings and possibly transmitting the virus. So, I mean, the early days of this, been in early August, we wrote the Prime Minister as an association on behalf of our members and said, look, if you're going to proceed with the mandatory approach, we're largely going to be supportive of that, subject to a few of our concerns being addressed. One is around the human rights issue. You've talked at length about that, dealing with health accommodations and legitimate religious accommodations. The second point that we had in our letter, which you've raised, which now we've all seemed to gone quiet on, is around the legal backstop in the event that legal action is taken against an employer for a mandatory approach. There was certainly a lot of chatter in August about that being provided to employers, and I have not heard much about it since. And I think you agree with me on that point. And the third thing that we've raised is just this whole issue of business continuity. I mean, obviously the economy needs to keep moving, and there will be circumstances where some exceptions may be needed. So to us, the argument has always been, why not sit down and have a consultation with key stakeholders or stakeholder associations and kind of talk through what this might look like and where there might be pitfalls and problems, and we could come up with a solution together that sort of walks us into the future. Right now, I think there are tons of questions. It's going to be kind of messy as we work our way through these early days of deadlines coming up. And there's still work I think that could be done, and we'd be more than happy to be a part of that.
While we're on this topic, I'll just jump in quickly because there was a question from the audience, but I think it will be helpful for the rest of the group to hear it too. So it was a question about what happens when employees refuse to comply with a mandatory vaccination policy and are then become unemployed, whether they're placed on leave or they're actually terminated, and what are their eligibility entitlements for EI. And interestingly, the EI form and the guidance was recently updated on this point. So they actually clarified, and I'm just going to read it out so I get it accurate, but that if an employee doesn't report to work because they refuse to comply with the mandatory vaccination policy, use code E for quit or code N if you're going to place them on a leave of absence. And if you ultimately do terminate an employee for not complying with your mandatory vaccination policy, they say use code M for dismissal. And they're insinuating that there's going to be a bit more of a detailed sort of investigation into the nature of your policy. So they say that someone may reach out to contact you and determine if the policy has been clearly communicated to employees, if the policy is reasonable in the circumstances. So there's sort of analysis as to whether there may be actually just cause essentially for dismissing someone for not becoming vaccinated. So that's an interesting update. And with that, I think I'll, sorry, go ahead, Stéphane.
Oh, thanks, Jackie. I will leave it back to you.
Okay, perfect. And I'm going to move along with the topic of pay equity, which, like many of the topics we're trying to cover today, is a huge topic, and we certainly can't cover it in the 10 minutes that I've got. But it is a really important one to flag for federal employers. Anyone who's got 10 or more employees in the federal sector should very much be turning their attention to this legislation. So the legislation, as you probably know, came into force at the end of this summer. It was a key element of the Liberal government's last platform. And so they tried to ensure that it was enforced before they went into this election. For those of you who haven't already done it, your first posting was due on November 1st, so yesterday. Even if you're not required to have a committee, you do have to have a posting if you have that 10, if you meet that 10 or more employee threshold. The Pay Equity Commissioner has a template on her website, though as is often the case, it includes a lot of information that you don't actually have to put in your policy. So we recommend a more pared down version. That notice, once it goes up, it's got to stay up until you complete your pay equity plan or until you're approved for multiple plans or a group of employers. But I'll get to that in a moment. But essentially, once that notice goes up, whether it's posted electronically or physically, it's got to stay there for roughly 3 years until you got your pay equity plan finalized. So something important to get right when you do it the first time. We're happy to share our template with you if that's something you would like help with. At a very high level, again, very, very high level here, what is the Pay Equity Act? So it's trying to ensure that there is equal pay for work of equal value for female-dominated job classes. So what is it not? It's not about individual comparisons. It's not about ensuring that two people in the same role are paid the same based on their gender. It's also not about wage increases for male-dominated job classes. So it's really just female-dominated job classes and trying to assess whether those job classes are paid equally for the work of equal value that they're performing with other male-dominated job classes. There's a lot of technical language in this legislation. I will say it's a bit of a mouthful when you're trying to explain it, which becomes a communications challenge for a lot of employers who are trying to sort of deliver more simplified messages about what the Pay Equity Act is. But it does become important because you want to ensure you're using the right terminology. There's a lot of opportunity to misapply the terminology and really come out with very divergent sort of objectives. So next slide, please. At a very high level, again, what does this legislation require you to do? Well, over a 3-year time span, employers have got to analyze their pay practices and analyze their compensation, analyze the value of the work performed by by job classes within your organization, develop a pay equity plan, post it, and close wage gaps. And that's within the 3-year period. After that, you do also have to engage in pay equity maintenance every 5 years. There are going to be various reporting obligations along the way. Next slide, please. So just to get in and give you a sense of what is involved, hopefully you've heard about this legislation already and you have some sense of the mammoth task that is unfortunately ahead of you. And I will say, unfortunately, most employers agree with the sort of premise of pay equity, but like anything, the devil is in the details. I think the hope was that with this proactive legislation, you would take out the very lengthy and extensive litigation that was occurring for a lot of employers in the federal sector. We saw cases playing out over 30 years, 20 years, 15 years. And the idea was that by moving to a proactive regime where you've got every employer across the sector participating in it, you take out the sort of unfortunate result for those employers who happen to get stuck with a very large claim that plays out over 30 years. So you're treating everyone in the industry equally, and you're not creating sort of unusual results in the job market. But also that you would compress the timeline. So somehow by working together and doing this in a committee, which I'll get into in a moment, is the default for large employers or unionized employers, that it would take the litigation out of there. I'm not so optimistic. I think that at all of these decision points here, there are 1,000 micro decisions that have to be made. And particularly where that's done in an employee-employer committee, there are many, many, many opportunities for friction and disagreement. And so I don't think I'm nearly as optimistic as the government was that this is going to be a harmonious, easy process. Where I see the particular points of friction, and part of this is actually looking at what unions and union council are saying about this legislation, but we think there's going to be a lot of disagreement in the valuation of work. So once you've, again, very high level, once you've determined the job classes in your organization, determined the gender predominance of those job classes, are they predominantly male, predominantly female, you've got to come up with a evaluation of the work that's done by all of those job classes. And what we have seen, particularly in the very large litigation that's played out, and again, what we're hearing from Union Council now is that there's going to be a lot of pushback from unions about using standardized valuations. So you've got the Hicks point factor system, for example, a very well recognized system, but we think that there's going to be pushback from unionized members who are on the committee making these decisions with the employer about using those existing systems, and are going to be pushing very much instead for kind of individualized, tailored job evaluation systems that work just for your workplace in particular. So that process can can kind of draw out again this pay equity process extensively and lead to a lot of confrontation potentially, and a lot of work. But once you've done these job evaluations, you've got to identify total compensation. Again, under that one subheading, there are a million micro decisions that have to be made. The federal sector in particular has a lot of very unique compensation models. So in the rail business, in the Canada Post, you've got very unusual systems that have been negotiated between the employer and the unions over decades, and that don't sort of align with the typical salary structures that we see at a lot of other organizations. So that again makes valuing compensation really challenging.
Hey,
Derrick,
Jackie.
if you want to jump in.
Yeah, I was just gonna say, I think you're bang on. I mean, I'm trying to serve as best I can as a conduit for questions from our members to the commission. Sometimes, in some respects, to give folks some cover so that I can ask questions on their behalf. And what I will say is I'm finding exactly as you just suggested, and that is there are so many micro decisions within each of these buckets that on paper it may seem like a pretty straightforward process, but I'm getting just tons of very specific questions from employers who are trying to sort certain things out. And the real challenge is these timelines are not flexible. So the Pay Equity Commissioner has no authority under the Act or the regulations to extend the 3 years. The 3 years is the 3 years. So that may seem like a long time. I think it's a blink in reality for all the work that needs to be done to complete the list of things you have on this slide.
No, that's exactly it. But there's just so much work to be done. And again, because of the complex nature of like these, again, a lot of you on this call have worked with your unions over the years to develop these really extensive systems that now you've got to unpack these compensation systems. So you've got to unpack and break apart in a way that you just never envisioned having to do. And your compensation systems reflect the nature of the work and the nature of your business. But unfortunately, when they were drafting the Pay Equity Act, they weren't thinking of your systems particularly when they were designing this. So there's going to be an immense challenge for those, particularly who have to do it in committee. Next slide, please. I put up the committee requirements here. Again, I won't get into them in detail, except for to say that you do have to, I'm sorry, it looks like some of my text is missing on one of those boxes, but except for to say that you do have to, if you're an employer with 100 or more employees or unionized employees in your workforce, you've got to do this entire exercise in committee. And the committee members are prescribed by the legislation. From a practical perspective, the employers we're working with right now, I have seen very few actually get to the stage of setting up their committees. And what we tend to see instead is that they're doing a lot of planning work now. They're really thinking about what the committee will look like in their organization and projecting more towards, let's say, March, April, May next year to get the committee sort of going. Once you get it going, there's a lot of training that's got to be done and a lot of other things that have to be considered. Within the requirements of the legislation, you're certainly not stuck to these minimum requirements. So the Pay Equity Commissioner does have an IPG on their website that gets into some of the other considerations that you might want to think about. Are you going to have geographic representation, for example, different representation from different parts of your business? So there are a lot of things that you can think about and strategize. Practically, though, you probably want to identify who your employee members are before you start putting your employer members on, because you're going to have to ensure you meet gender parity or the gender prescriptions and other things. Derrick?
Yeah, I was going to say, and it's really complicated in large organizations where you have multiple bargaining units. There are probably folks on this call today who work in organizations where there are 8, 10, 12, 15 bargaining units to sort that all out within the context of the committee is going to be a real exercise for sure, and meet all the criteria that are there. The issue that certainly we've been raising from the very beginning of the process around developing this act is the whole issue of confidentiality. This committee is going to get access to compensation data in a way that has never existed in the federal private sector. And there will be employee and union representatives on this committee having access to that same data. And the confidentiality of that is baked into the act. But certainly there are concerns about, that sort of information leaking out throughout the organization and sort of, getting in the way of effectively getting to the end of the process of developing the pay equity plan.
Yeah, absolutely. And that's why a lot of the employers we're working with right now are in that planning phase, drafting confidentiality agreements, drafting terms of reference, so that they can very much sort of be out ahead of these issues as much as possible. You're never going to be completely. It's also a consideration for a lot of employers in driving their decision to apply for multiple plans, which we'll get into in a second. Just for everyone's reference, that box that is empty actually points out the fact that the non-unionized employee representative, it refers to the definition of non-unionized employee in Part 1 of the Canada Labour Code. So employee who's not involved in labor relations and is not a manager. So those representatives cannot come from those groups. It's really just your sort of non-unionized employee at the lower level who wouldn't have involvement in compensation decisions. I could talk about this for another 5 years probably. And I will say, if this is something that those on the call would find valuable to have a more in-depth dive on the Pay Equity Act again, please let us know in the comments, because it's certainly something we could set up. But I'll go to the next slide now quickly, just to talk about the issue of multiple plans. And there is a test under the Act, and I do really want to point out, because this often is missed by employers, that there's a sort of data-driven threshold issue of whether there are enough predominantly male comparators in the pay equity plans that you're proposing. So you couldn't have you couldn't propose multiple plans where one of the plans has an insufficient number of predominantly male comparators that would frustrate the pay equity exercise, that would frustrate the ability to run the comparison. That enough is considered from both a quantitative and qualitative perspective by the commissioner. You've really got to do the exercise of understanding where your male-dominated job classes fit. Do they have high number of incumbents? Are they a new job class? Are they distributed across various levels of values, or are they sort of concentrated at the top, but then your female-dominated job classes at the bottom aren't going to have a sort of sufficient number of comparators? So that's a very data-driven exercise, and it's a threshold issue. If you don't meet it, then the commissioner has to deny your request. And then she gets into a more sort of evaluative, a more subjective, I would say, review of whether the plans are appropriate in the circumstances. Again, there's a lot that goes into that analysis. There are a lot of resources we can draw on to sort of inform what we think she's going to be looking for in those sorts of areas. She's got her IPG. We can also go back in time and look at the Bilson report, which sort of underlined the new Pay Equity Act and really sort of informed how it was conceived. There's a lot of really interesting stuff in there, but there's no sort of straightforward, easy manual for employers on this front. Derrick, I know this is a huge issue for all of your members, and all of our clients really too. So.
Yeah, Jackie, hands down, the number one issue within the confines of this act is multiple plans. So as you have on this slide, the default position is a single plan. That was by design within the act. They believe that was the better way forward to avoid some of the challenges as have been seen in the Ontario and Quebec models. Unfortunately, for most of our members who are large employers that are coast to coast to coast with many, many bargaining units in unionized shops, that's not how they see themselves. It's really complex. And I would say across our membership, almost all of our members will be applying to the commissioner for the right to proceed with multiple plans. And they're now going through that analysis to see how they might make those arguments. Tons of questions coming in. There is, as you say, support material and IPG on the commission's website to explain this, but it's pretty high level. And it does, it reads a bit subjective that the application will be received and then the commissioner and her staff will review it and then make decisions accordingly. They have provided some sort of high level criteria. So we have been in constant contact with the commissioner and her staff to say, you know, can you provide us more detail, some sort of a template or a checklist or more detailed criteria around what might make a better argument for a multiple plan application. And I'm actually a bit encouraged because they're receiving those comments very well. And I think they're trying to sort through this to provide greater clarity, because I think they're going to get an onslaught of applications. They're not coming today because I think folks are still in the early days of getting their applications together. But as you noted earlier, in terms of where employers are in this process, I don't think many have struck their committees yet. Many are doing that due diligence to get ready. And this is one of those issues because the committee structure itself will really hinge on whether or not the multiple pay plan is accepted. So our members we have been coordinating and sending a series of questions into the commission to see if we can get some greater clarity on this particular issue, because it's hands down the biggest issue for large employers.
Yeah, no, that's exactly right. And the commissioner's established a process whereby you've got to do a request for information before you can even kind of get to the stage of submitting your application. You're put in 2 tracks. Are you an employer who has evidence of employee support for the multiple plans or not? Even what they're looking for on that front is not very transparent at this stage. So as you said, there's so much to unpack in here. Practically, what we're seeing from most of our clients is that they're not doing the application yet. They're planning on doing it again later in maybe early 2022. Although there are some who are sort of getting the process started now. So lots to think about.
And I would say, I mean, generally speaking, kudos to the commissioner and her team. I really think they're working hard to respond to the questions and concerns that are coming in. She has a very competent team of people around her. They're very responsive. They endeavor to answer any questions that come in quickly. They are developing a series of tools and templates that are on their website to help employers. I think much of that is really going to help small and medium-sized employers that are probably a bit more easily organized. But what we're hearing are the real detailed questions from large employers where we need greater clarity from her. And to their credit, they're pretty responsive to that. And I'm optimistic that we'll find a way through this.
Yeah, no, I think that's right. And we're lucky we've got the Commissioner Redo. She comes from a background where she has been a management side labor and employment lawyer, amongst other things, and she understands the key challenges and issues, but at the same time, she's got a mandate that she's got to fulfill. So I'm conscious of time. I'm going to very quickly go to my next slide, please, where I've set out some of the considerations. I'm just going to leave this with you more than anything. There is a lot of work that employers are proactively trying to do here to really think about things and understand what this process might look for them once they get to the committee stage. So again, this is just a resource for you more than anything. And with that, I will turn it back over to Stéphane to finish us out and hopefully leave a little bit of time for questions.
Yes, I can do it in like 2 seconds. So maybe just a bit of information. You might maybe switch to the next slide. So I'm just going to mention in terms of the National Day for Truth and Reconciliation that was added, in the summer. You might know, for some of you, most employers actually decided to aim to give it to employees. Maybe switch to the next slide to explain my comment. Most employers decided to go and give the additional day because they didn't want to get into a fight on something that can be pretty emotional, if I can call it like that. But some other employers took the positions that because they had at least 10 general holidays, they didn't have to grant it because of 168 1.1. There's going to be actually a couple of litigations that will take place in the next few months, and we'll keep you informed. That would be all for me on this particular subject. If we want to leave, maybe if you have some questions, we'll have another 8 minutes if some of you want to send additional questions and that we can try to answer. So maybe I can start with.
Thank you. Yeah.
Maybe I can start with
Stéphane.
with one that is listed for you, actually, Jackie. So what could happen if an employer is late on posting the notice on pay equity?
So you could use subject to sanction under the Act. I think practically at this stage, you're 1 day late. Hopefully you can get it out there as soon as you can. You've got to post it electronically or in hard copy. You don't have to do both. The electronic posting can be relatively simple. Send an email to your workforce with a link to the notice, or even just include it in an email itself and then post it somewhere afterwards. So I wouldn't, from my perspective, the posting of the notice is not sort of a capital punishment itself. Though if you do have unionized workforce, if you've got unions in your workforce, then I would be very careful about all of your compliance efforts, because they're going to be holding your feet to the fire. And more than anything, I think they'll use the evidence of the fact that you haven't complied with the requirements later on, if they're trying to get something else out of the commissioner and sort of get their way on another issue. They'll use this as evidence of the fact that you don't really care about complying with the Act in the first place. So from my perspective, that's the bigger concern.
Maybe a question now for Chris and Derrick, and I'm just going to go back to the 10 sick days that we were talking about at the beginning. From what you're hearing, are we talking about sick days that would be paid by employer, like some of the personal days?
I think my answer to that, at least, is yes. That is how I understand the Liberals' current policy proposal. But as Derrick mentioned, I think in his comments on this issue earlier in the presentation, obviously the addition of 7 paid days off for employees is a pretty onerous financial burden, a new financial burden that employers would need to bear. So I think it's an open and important question. Derrick?
Yeah, I agree with you. I mean, it's not to be inhumane. Who can argue against paid sick leave, especially after what we've lived through with COVID? But 10 days, if it's 7 or 10, if the employer is paying, that is just an enormous cost if those leave days are used. So we are hoping that we can have a meaningful discussion with the government about what this means and how this might be implemented.
So thanks everyone. So we've covered pretty much all questions. If there are others, we'll be happy to reply directly. At this point, I would like to thank everyone for joining us today. Our next webinar, as Jackie mentioned at the beginning, is the Year in Review series. It's going to be on November 9th, and it will cover employment litigation. You can visit the Fasken Institute section of fasken.com to register. And on behalf of everyone here, I would like to thank you for being here, and we hope you've learned from this presentation. Thank you.